6.3, fourth affirmative defense, qualified immunity. Defendant's fourth affirmative defense asserting qualified immunity along with sovereign immunity, legislative immunity, and or absolute immunity should be stricken as legally insufficient and properly pleaded. The qualified immunity defense fails to meet the pleading requirements established in Harlow and subsequent precedent. Qualified immunity is unavailable to municipal defendants. Owen categorically held that municipalities may not assert good faith of their officers as a defense to Section 1983 liability. The Supreme Court emphasized that municipalities face strict liability for constitutional violations, regardless of official subjective intent or objective reasonableness. The city cannot cure this fundamental legal deficiency through amended pleading. Strict liability. You hear that? That means you're just guilty if this happens. That's the whole point of strict liability. You can't get out of the wrongs. Like, oh, I'm sorry. No. Okay, well, yeah, that's great. You're sorry. Now you have to pay. Even if properly pleaded by individual defendants, qualified immunity would fail under the Harlow standard, which protects officials only with their conduct that does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Defendants' unified immunity defense reveals a fundamental conflict of the interest that renders the pleading inherently deficient. Oh, yeah. The city have diametrically opposed strategic interest regarding immunity. 635. A joint representation of conflicting interests explains the defense's fatal vagueness. Defendants cannot plead specific facts supporting immunity because any factual allegation would benefit one defendant while harming the other. This conflict renders meaningful pleading impossible and creates the unfair surprise rule 8C prohibits. The unified defense, in which multiple defendants assert a collective claim of qualified immunity, obscures the individual legal position each must articulate to enable a clear evaluation of their defenses. This collective approach hinders the court's ability to resolve the case on its merits, creating confusion about which legal theory applies to each defendant. In Goodyear, the concealment of evidence similarly frustrated the judicial process, underscoring the importance of clarity in litigation to uncover the truth. Just as Worth requires plaintiffs to clearly establish standing to invoke the court's jurisdiction, defendants should distinctly present their defenses to facilitate a fair and accurate resolution. Defendants' qualified immunity defense must be stricken because 1, it fails to meet basic federal pleading requirements. 2, municipalities cannot assert qualified immunity under binding Supreme Court precedent. 3, the joint defense creates irreconcilable conflicts between co-defendants that prevent proper factual pleading and create unfair surprise. Are you reading the motion described? Yeah. All right. 6.4. This is where we tackle, or where Tracy tackled, sovereign immunity, absolute immunity, and legislative immunity. Defendant's fourth affirmative defense also asserts that plaintiffs' claims are barred in whole or in part by the doctrines of sovereign immunity, legislative immunity, and or absolute immunity. This defense is legally insufficient because sovereign immunity does not shield municipalities from Section 1983 liability. In Monell, Supreme Court explicitly held that municipalities are persons subject to suit under Section 1983 and do not enjoy sovereign immunity from such claims. The court reaffirmed this principle in Owen, stating that there is no tradition of immunity of municipal corporations in neither history nor policy supports a construction of 1983 that would justify it. The municipal defendants in this case cannot assert sovereign immunity as a defense to plaintiffs' 1983 claims. 643, absolute prosecutorial immunity is narrowly constrained by the Supreme Court to protect only actions taken in the intimate initiating of prosecution and in presenting the state's case. Not every action a prosecutor performs. This limited immunity shields only functions that are intimately associated with the judicial phase of criminal process, while providing no protection for administrative or investigative actions. Critical to this case, when the prosecutor are sued in their official capacity as representatives of a municipality, they cannot invoke personal immunity defenses to protect the government entity from liability. As the Supreme Court explicitly stated in Kentucky, in an official capacity action, personal immunity defenses are unavailable. The fact that the underlying prosecution in the case was dismissed specifically due to constitutional violations provides conclusive evidence that the prosecutor's conduct fell outside legitimate scope of prosecutorial functions protected by immunity. When the prosecutor violates constitutional rights, they step beyond the boundaries of protected advocacy into unprotected misconduct. The court, this is a quote from Burns v. Reed, the court therefore held that prosecutors are absolutely immune from liability under Section 1983 for their conduct in initiating a prosecution and in presenting the state's case, insofar as that conduct is intimately associated with the judicial phase of the criminal process. Decisions in later cases are consistent with the functional approach to immunity employed in Imbler. These distinctions have also emphasized that the official seeking absolute immunity bears the burden of showing that such immunity is justified for the function in question. The presumption is that qualified rather than absolute immunity is sufficient to protect government officials in the exercise of their duties. We have been quite sparing in our recognition of absolute immunity and have refused to extend it any further than its justification would warrant. That's Burns v. Reed, 1991. Well established, well known. Legislative immunity is wholly inapplicable in this case, as the complaint does not challenge legislative acts done by the defendants. Legislative immunity applies only to actions taken in the sphere of legitimate legislative activity. The Supreme Court has emphasized that this immunity is limited and applies to only legislative activities. Defendants have not identified any legislative acts at issue in this case, nor could they.